We now move out into the World Wide Web with a presentation by Helen Keller. Welcome. Helen, can you hear us?
Yes, I can.
Okay, and we can hear you perfectly well as well. Helen Keller has been a full-time judge at the European Court of Human Rights in Strasbourg from 2011 to 2020. She has been awarded an honorary doctorate by the University of Freiburg in 2018 for her contribution to cross-fertilization of doctrine and practice. In 2020, she was awarded a recognition prize for the Foundation of Western Ethics and Herzegovina, Ethics and Culture, and since 2020, she serves as a judge at the Constitutional Court of Bosnia and Herzegovina. So thank you very much for being with us this morning, Helen. We move from science to the courtroom, to the judges. I think the floor is yours immediately. It's up to you.
You see my title, Experts and Judges. This is not a dream team, it's rather a mésalliance. And why this is, I only can speculate. But before I do that, just give me a moment and I'll try to give you an overview about what I want to present. I go first in the introduction to speak what is the court or what I mean by that. Then I go to the big issue of admissibility because the scientific question always comes after admissibility. Then on certain facts, usually we have scientific evidence on questions of facts, not so much on questions of law. Then I present from my experience 2 examples that I had, and I come back once again whether there is a possibility to have expertise on questions of law. I quickly go to the questions, are there good and bad experts? Who bears the costs for expertise? Then I try to give an example on expert language and how this has to be translated. And I will conclude and speak about this mésalliance. As I mentioned, there is a certain distrust between judges and experts. I don't know exactly why, but I'll come back to that at the very end. When I speak of the court, I am referring to very specific people behind the scenes. In every procedure, the rapporteur plays a prominent role. For many procedural questions, he or she will make a request to the president, either of the chamber or the grand chamber. The president then formally takes the decision. Often he or she adopts the rapporteur's proposal without discussing. Only for very important procedural steps will the chamber or the grand chamber be convened. In addition to the rapporteur and the president, the registry also plays a central role as a grey eminence. Although the case lawyer does not decide, he or she will submit important questions and proposals to the rapporteur. These suggestions may include that a hearing of the parties or of experts or of witnesses could be ordered. These proposals may, of course, also come from the parties or from third-party interveners. We all know the biggest hurdle at the European Court of Human Rights is admissibility. Over 90% of cases fail on this, very many on the criterion that the case is so-called MIF. This is the internal jargon for manifestly ill-founded. It needs no further explanation that it is only when a case has cleared this hurdle that it has reached a point where the inclusion of experts is possible. If a case is not declared inadmissible in the single judge procedure, most cases by now are communicated in the so-called IMSI procedure. That means in the immediate simplified communication system. This is an important point that many outsiders underestimate. In the IMSI procedure, the government is served with the case with a request to present the procedural history of the case and the facts. The government will do this to the best of their ability. This statement will then be submitted to the applicant for comment. It is important to understand that the facts apply as presented by the government if they are not disputed by the applicant. Because expert opinions often concern facts, not questions of law, it is eminently important to dispute the government's presentation of the facts already at this stage, to submit one's own presentation of the facts to the court, and if necessary, to point out the issues in dispute and the possibility of an expert opinion. If the applicant fails to dispute the facts, the court will adopt the government's version of the facts. Allow me to make here a preliminary conclusion. As a rule, the court will not seek expert opinion to answer questions of law, in particular not human rights law questions. The clarification of legal questions is left to the court, but I'll come back to this when I present the two examples. When certain facts are disputed, the court has various ways of dealing with this uncertainty. In simpler cases, both factual variants are included in the judgment, and the court decides which variant it considers more convincing, sometimes applying certain rules of evidence or reversal of burden of proof. The reversal of burden of proof is typical in cases where the court has to judge the ill treatment of persons in state custody. Sometimes expert opinions obtained by the parties are simply attached to the case file. These expert opinions are read by the case lawyer. However, they are weighted as party opinions and not necessarily as objective opinions, with maybe one big exception, and these are medical certificates. Finally, it sometimes happens that the court asks the party to obtain an expert opinion. This is often the case when it comes to expropriations, and the court needs an expert opinion to be able to determine the compensation for damage that the state should pay to the expropriated person. As a rule, the government will then demand that it may also have the value of the expropriated property estimated in a government expert opinion. More difficult are constellations where more complex issues require expertise. This is the case, for example, when new scientific questions arise. This happens often in the court's practice in Article 8 cases, when medical issues are at stake, such as access to reproductive or abortion techniques, or the authorization of medicines. The climate lawsuits currently pending before the Grand Chamber raise entirely new questions as well. I go to the two examples. In the first procedure, it is Barilla versus Italy from 2015. Essentially, this case dealt with ethically difficult questions of what may be done with surplus embryos that are not used in vitro fertilization. May the state order that the embryos be kept indefinitely? Are the parents allowed to decide about the surplus embryos? What happens if they, among them, disagree? Can research be carried out on these embryos? These are difficult questions, and you may have guessed it. The court was restrained in its judgment and gave the states a wide margin of discretion. However, it seems important to me that various organizations and experts submitted applications for third-party interventions in these proceedings. Third-party interventions offer a low threshold possibility to submit a certain expertise to the court. However, the effect of this expertise is also limited. The third-party intervention is usually part of the dossier that the judges have to deal with in the case, but the third-party intervention is summarized in the rapporteur's report or then in the judgment to 1 or 2 paragraphs. If one is unlucky, this expert opinion will have been read by the case lawyer and the rapporteur, but not by all the judges. A third-party intervention receives much more attention if the request has been made that the third-party intervener can also present orally during the hearing in the grand chamber. I would recommend this to every expert who has an important message. It is true that you then have to break down the expertise to a core about 10 minutes, but this has the advantage that all judges can listen and even ask questions. The second case, which required a lot of expert knowledge, was not an individual case but an interstate case. I was involved in the case Georgia versus Russia number 2 from 2021, which essentially dealt with the question of whether Russia had violated human rights during the 2008 war between Georgia and Russia and during the subsequent occupation. The difficulty in this case was that the factual situation was disputed by the two states. The court struggled with not being able to travel to the disputed territories of South Ossetia and Abkhazia. It was therefore not possible to have an on-site inspection or to question witnesses in those two territories. Instead, the court decided to hold an extensive hearing of witnesses and experts, those provided by the parties and those convened by the court. The expert opinions submitted by the parties were mainly of no help. Their independence was doubtful. Those experts invited by the court proprio motu, on the other hand, were, in my view, very helpful. On the one hand, they showed the limits of what the court can do at all in such proceedings. On the other hand, the court was able to clearly qualify certain claims of the parties as false on the basis of these expert opinions. It was certainly crucial that these experts were present, that they were questioned in cross-examination of the parties' representatives, and that the judges could ask them questions. This very elaborated procedure demonstrates both the quality and the independence of those experts. But it makes also clear the court has neither the time nor the resources to conduct such an elaborated procedure for all cases in which scientific issues are disputed. I come back here to the question whether the court can ask expert opinions on questions of law. As a rule, I would say the court only seeks expert opinions on questions of fact. In this case, however, in Georgia versus Russia number 2, the court asked the International Committee of the Red Cross for an opinion because the proceedings also involved questions of international humanitarian law. However, the ICRC refused to comment because it considered this incompatible with its neutral role in a war. So, exceptionally and theoretically, the court might also invite experts to give his or her opinion on a question of law, but this is the exception and concerns a specific field of law, certainly outside of human rights law. I come to the question, are there good or bad experts? Whether an expertise corresponds to the state of science cannot be answered simply. Experts should be selected according to objective criteria. An affiliation with a renowned university or publications are an indication of that quality. To a certain extent, it is up to the parties to question the reliance of an expert if there is evidence to do so. However, we must not harbor any illusion. The court has no absolute guarantee that an expert is really up to date with the latest scientific knowledge, nor that he or she is truly independent. A remark on costs. Party expert opinions are paid for by the parties. If the court invites an expert, only the expenses are reimbursed. So the actual costs for the expert opinion are not reimbursed. To make it very clear, you do not get rich if you are invited by the court to provide an expertise. Expert language. I would like to use the example of the climate cases pending before the European Court of Human Rights to show that experts and scientists deal with the same or similar question, but they use different terms than lawyers do. It seems important to me that both the judges and the experts learn that they have to translate their own terms into the language of the other group. The different uses of language is one of the big obstacles to judges and experts not always understanding each other easily. Let's take the example of victim status in the Klimaseniorinnen case against Switzerland. The central issue here is whether older women are more affected than others by global warming during hot summers. In the terminology of scientists, this is about statistical excess mortality. These terms have to be transposed from one language to the other, and the lawyers would use the victim status and the vulnerability of a particular group. We can observe something similar if we go to the question whether Article 2 and 3 of the Convention are applicable ratione materiae. Both articles require a certain intensity of the threat. For scientists, this raises the question of the occurrence of risk. With what probability do we have to assume that climate change poses an imminent threat to elderly ladies? For the court, on the other hand, this is a threshold requirement in the context of Article 2 and 3. I come to my last part. Not hate, not love, rather a mésalliance. I come to the question of why judges are suspicious of experts. There are several reasons for this, and it goes without saying that I cannot answer the question for a specific judge, but only formulate my assumptions here in a general way. Not only since the COVID-19 pandemic, but increasingly since then, there has been a growing skepticism of science. Science is portrayed as arbitrary and sometimes even denigrated. This tendency also leaves its marks on the courts. The involvement of experts is often considered unnecessary because it prolongs, complicates, and increases the cost of the procedure. Judges often feel overwhelmed by the expertise. These are sometimes extensive and difficult to understand. Judges often fear that the expertise makes the decision unnecessarily more difficult. They sometimes experience that they know even less what to decide, are even more confused than before the expertise, but are now confused at a higher level. The responsibility in a court case ultimately lies with the judges. This means that the judges do not necessarily want to have even more information for the basis of the decision because they shy away from complexity. Thus, a certain blinker mentality of the judges towards the expert becomes apparent. I conclude. Expert opinions are used more frequently at the court than one might think. There are very different expert opinions, mainly those of the parties and those obtained by the court. The financial resources for expert opinions are very limited. This limits the choice of opinions from the outset. How favorable the court reacts to a request to submit an expert opinion depends not exclusively, but nevertheless to a quite large extent, on the attitude of the rapporteur. The more favorable he or she reacts to such requests, the greater the chance that the expert opinion will be admitted to the court. Experts have various possibilities to get in touch with the court. Third-party interventions is a low-threshold opinion. Here the request comes directly from the experts. In this procedure, it is useful to request an oral presentation during the hearing in addition to the written submission. This is the only way to get into an exchange with the judges. The expert can also contribute their expertise via the party's submission. However, a party submission is always read with a certain skepticism. Finally, in rare cases, the court invites experts itself. Because the resources for this are very limited, this rarely happens. I thank you for your attention.
Thank you very much, Helen. Maybe you can unshare your presentation so that that everybody can see you again. Thanks for staying with time as well. We have a couple of minutes for a question or two from the room, from the floor to the judge. Any things you would like? Yes, please.
Thank you. Thank you very much for this very enlightening presentation.
Can you just present yourself so Helen knows who is talking?
Apologies. My name is Stephanie and I'm a legal officer with the Global Legal Action Network who supports the young applicant in the Duarte Agostinho case pending before the Grand Chamber. My question relates to Helen Keller's last point regarding the likelihood of expert being appointed by the court. And I'm just curious to know Helen's opinion as to the likelihood of such experts to be relied upon by the court in climate cases, given the really novel and new questions that are brought forward by the parties, and how important it would be for the judges, for instance, to have their own experts appointed in those cases. Thank you very much.
I think there are in the room persons present that would be more able to speak on that. As far as I know, in the proceedings pending before the court, quite a lot of experts have asked to be allowed to present a third-party intervention, and at least in the Klimaseniorinnen case, some experts from the really scientific field are admitted, not all. Here we might come back to third-party interventions. I told you it's a low threshold to get in, but one also has to say it is a little bit of a black hole whether the court allows a third-party intervention or not. It is completely in the power of the president to allow a third-party intervention or not. And then I think very practical consideration come into play. If you have a grand chamber and you already have, 15 third-party interventions admitted, and then comes a 16th, a 17th, at a certain point you will just say it's enough, because you have to deal with the dossier at the end of the day. So, I would say try to get in, try to say it is really an important issue, and try to say it is so important that it would be useful to present the main message during the oral hearing. But you have no guarantee, no right to do that.